Okay, again, my name is Paul Thaler. I am with the National LGBT Bar Association. We want to thank our listeners for calling in today to listen to this important topic. The LGBT Bar is pleased to host this call-in regarding the Whistleblower Protection Act with our distinguished panel of speakers. With a recent change in administration and tumultuous confirmation hearings of cabinet appointees, the LGBT Bar is holding this call-in response to numerous requests from our members to address the process for government employees who witness unlawful acts. The call-in will cover whistleblower rights as well as the process of reporting misconduct in governmental agencies. I just want to make this announcement now to all of our speakers that if you have any questions, to all of our listeners, that if you have any questions for our speakers throughout this process, please email questions to me at paul@lgbtbar.org, and we're going to try to get to as many of them as possible at the end of this call-in. Before we get started, I also just want to give some brief speaker introductions for the three speakers that we have today. The first is Richard Condit, who is of Counsel with Mehri and Skalet. Richard heads the firm's whistleblower law practice, including cases involving whistleblower retaliation, disclosures to the SEC and other federal agencies, and false claims or fraud against the government or its contractors. He has 25 years of experience working with whistleblowers and has handled many whistleblower cases covering an array of subject matter. Prior to joining this firm, he was senior counsel at the Government Accountability Project, served as general counsel for PEER, and as the legal director for Land and Water Fund of the Rockies. While at PEER, he and his colleagues litigated the whistleblower case of former U.S. Park Police Chief Teresa Chambers to a successful conclusion. He is adjunct faculty member of the University of District of Columbia School of Law. For about 7 years, he has taught whistleblower law and practice in the classroom and through the school's highly regarded clinical program. The next person that I'm going to address is our moderator. She is Julie Chovanes, who is the founder, executive director, and legal program director for Trans Resource Foundation. In addition to her work with the Trans Resource Foundation, Julie is the managing partner of her law firm, Chovanes Law LLC, a patent intellectual property and corporate law firm. Previously, she was a partner at DLA Piper. She has over 20 years of federal litigation experience in both significant commercial cases and significant trans rights cases. Julie has written, taught, and spoke to medical schools, graduate schools, legal, and other groups about trans and LGBT issues, and been featured as a trans and LGBT advocate in national and local media. And our last speaker on this panel today is Laura Dumais, who is staff counsel for PEER, which stands for Public Employees for Environmental Responsibility. Laura graduated first in her class from Vermont Law School, where she focused on environmental law. Laura holds a master's degree from the University of Michigan's School of Natural Resources and Environment. Prior to her work with PEER, she clerked for the Vermont Superior Court's Environmental Division, which is a unique court with statewide jurisdiction over environmental and land use matters. She also interned for Judge Peter Hall at the Second Circuit Court of Appeals and worked with various nonprofit organizations, including the Center for Biological Diversity and the Environmental Working Group. And again, we thank our speakers so much for taking the time to be on this call today. I now am going to pass this over to our moderator, Julie, to begin the discussion on this very important topic.
Hi, Paul. Thank you. And thank you to the LGBT Bar, and hopefully our listeners will learn something today. The reason for this call was brought very, very starkly home to me when we were on a trans civil rights case in New Jersey. We contacted a person in justice who had helped us in a similar case in Pennsylvania. Justice was unable to help us because of the change in administration. Now, if that person, and I don't want to identify anyone specifically, which is kind of sad too, but if that person ran into situations where they are now encouraged to pursue policies that may be fraudulent or violative of other laws or regulations, they might be concerned enough to be a whistleblower. A whistleblower essentially, in many areas of the law, proclaims this is wrong. Whistleblowers may be subject to retaliation. And retaliation law is a separate but overlapping concept with whistleblower law. Some retaliation laws are contained within whistleblower laws. The scope of the laws are vast. There's so many, even the Patent Office, for goodness sake, has a whistleblower law. And what the Patent Office has and what so many federal agencies and departments have is a common process for dealing with whistleblower complaints. And that's the subject of this call. Not necessarily individual laws or policies or particular situations, although we have a question at the end for that, or hypotheticals as well. But what our panelists are going to talk about are how you or advise and or bring yourself these sorts of actions and what risks you may face. So now I'm going to turn it over to Richard and Laura.
Okay, thank you, Julie. So I'm going to start talking about two sort of broad topics. One is the question of exposing misconduct. So you or someone that you're helping see something that's going on that is a violation of law or some large problem, and the question is, where do I go? Who do I tell about this? And then the second broad topic I'm going to talk about is if you or someone you're helping has exposed a problem and you're facing pushback, you're facing discipline or whatever, you're facing a retaliatory action because of that, how do you then address that? What kind of whistleblower protections are in place to help you? So to go to that first topic, exposing the misconduct, there are various channels that you can use depending on what kind of law is being broken. In my field, we do a lot of whistleblower work related to and disclosures of misconduct related to environmental laws, but this would hold true for other types of laws too. So one avenue is that every federal agency has an inspector general's office. And so you could go to the IG's office to expose problems that are going on. But there are a few problems that we find with inspectors general, mainly that, unlike with the Office of Special Counsel, which I'll talk about in a moment, there's no real defined process when you're going to an IG. You can give the IG the information, and they can essentially ignore it. They can reframe the issue to look at some sort of trivial aspect rather than the more profound problem. They can even decide to investigate the person who brought the problem to their attention rather than other people. And so the IG can also be very, very slow. So these are sort of some major considerations to think about before you go to the IG or you advise someone to go to the IG. Another potential avenue that does have sort of more process is the Office of Special Counsel. And the Office of Special Counsel is it's an independent sort of agency, so anyone from any agency can go to the OSC with problems. And the OSC has two different functions. It has a disclosure process where you can go to expose the problems that you're finding and you want to blow the whistle on. So it essentially allows you to blow the whistle. And then the second thing that the OSC does is it handles complaints of whistleblower retaliation, which I'll get to later. So in terms of the disclosure process, again, the disclosure is not seeking really for retaliation, but just bringing the problem itself. What the OSC will do is it'll work with you to examine the facts, see what's going on, and if it determines that there's a substantial likelihood of validity, it then will refer the information to the agency, and the agency will investigate. And this can take kind of a long time depending on what the issue is. They're supposed to make the determination within 15 days, but in reality they're kind of timid about it, and they want to make sure they dot their I's and cross their T's, and so it can take far longer, months or even a year. And then the agency is supposed to then report back to the OSC, and then the whistleblower can comment on the agency report, which is like a very it's really a plus of the OSC process that the whistleblower then has the opportunity to comment. After that, the OSC makes an independent determination and can order additional review, and at the end it will transmit a report to the president and congressional committees saying what it believes is wrong or not wrong with what the agency did. So it has the advantage, as compared to the IG process, of transparency, but it can be a long process, and it's not always a surefire thing. But these are two different avenues, the IG and the OSC, that you can go to expose misconduct. Obviously, there's also the press, but that's
Hey, Laura.
Yeah, am I kind of going?
No. But
detail?
I want to ask a question. No, I want to ask a question on either of those two processes. My understanding is the time frame. In other words, this isn't like a 2-year statute of limitations thing. People really have to move fairly quickly from the time they become aware of the incident, right?
Well, it's helpful. I don't think, off the top of my head, I don't think that the OSC has any sort of statute of limitations, but the fresher the information is, the more likely they are to investigate it. And I've found situations where the OSC has said, well, that seems to me to be kind of stale, but what can you tell me about things that have gone on more recently? And they're more interested in the most recent things.
Okay, thanks.
Mm-hmm. So I'll just know in terms of going to the press, there are considerations there, and especially for attorneys who are trying to blow the whistle, and that's something that Richard will talk about a little bit later. But you don't want to do anything that's going to get you disbarred or censured. Okay, so that kind of wraps up for me the major avenues of exposing misconduct. The only other thing I would mention is that if you're working with a scientist who is raising a problem regarding his or her scientific findings, then that can be done through a scientific integrity policy, because it's not really a violation of a law, rule, or regulation. It's just political pressure on a person to change scientific findings, which wouldn't normally fall under sort of an OSC or an IG type of situation. So now I will try and just briefly talk about some of the whistleblower protections that are available to you or to someone you're helping if, in fact, you're experiencing, like I said, retaliation. So in 1978, the Civil Service Reform Act put in place what are called prohibited personnel practices. And these are things that are simply illegal to do in the realm of employment law. So, for example, an agency can't coerce political activity. An agency can't willfully obstruct a person's right to compete for employment. And so there are all these different things. There are 12 of them. Oh, there are 13 of them, sorry. And the ones that are most relevant for us, I'll talk about. So number 8 is whistleblower retaliation. So a federal agency is not allowed to retaliate against someone because they disclosed information that evidenced a violation of law, rule, or regulation, or these list of other things, including mismanagement, waste of funds, substantial danger to public health or safety. So this is what helps people who've blown the whistle and who have experienced retaliation. And the way that it helps them is that they can challenge the action that was taken. So say they were suspended, they can go to the Office of Special Counsel with a whistleblower retaliation complaint and ask the Office of Special Counsel to investigate. And what will typically happen is if the complaint has some merit, the OSC will kind of work out with the agency, some sort of settlement. Unfortunately, so the Office of Special Counsel is supposed to then, if the agency refuses to cooperate, it's supposed to act as a special counsel. It's supposed to act on behalf of the whistleblower and take the case before the Merit Systems Protection Board, but that doesn't happen very often. The Merit System Protection Board is sort of the next step up. It functions more like a trial court. And parenthetically, I'll just mention that there are certain things for which you can go directly to the MSPB, but those tend to be the more severe actions, like the person was removed from service or demoted or suspended for more than 14 days. But more typically, I think you'd do a whistleblower retaliation complaint at the Office of Special Counsel. The other one of the prohibited personnel practices that is relevant and of interest for this call in particular is, well, really two of them, number 1 and number 10. And if you happen to be by a computer, you might want to pull up the prohibited personnel practices, which are at 5 USC 2302B. So B1 prohibits discrimination on the base of race, color, religion, sex, or national origin. And although gender identity or sexual orientation is not listed there specifically, sometimes the OSC has used that to argue in favor of a whistleblower. To argue in favor of a person who's being discriminated against for that basis. And the other one is B10, which prohibits discrimination in employment for any basis of where the conduct doesn't adversely affect the performance of the employee. And the OSC has also used 10 in instances where someone has been discriminated against unlawfully on the basis of sexual orientation or gender identity. So you can imagine that there is a potential overlap situation here where someone is making a protected whistleblower disclosure involving a violation of some law, rule, or regulation that involves LGBT rights. We haven't seen this come up yet through, or at least that I'm aware of, and we did a little research in sort of the case law, but it's potentially possible. And if you go to the OSC's website, there's a resource page for LGBT issues that's actually really helpful, and you can spend some time exploring that. And it's just at osc.gov. /pages/LGBT resources, and you can find it there.
Now, I want to interrupt. First of all, you're running out of time, but secondly, part of what I find difficult as a trans civil rights lawyer is the weakness of our law, just generally. The EEOC has done amazingly great work and was the pioneer in including us as trans people under the sex discrimination laws. But it's a pretty fragile structure. So it seems to me that a practitioner or a complainant should be aware that you maybe don't want to depend on such fragile law. And like any complaint, you should use as many grounds as possible under which to claim that you've been retaliated against. I mean, that's a fair statement, right?
Yeah, I think so, and Richard might want to weigh in on that too.
Yeah, I think that, Julia, it's a very fair statement and a good point. And what I would say from my experience in working with whistleblowers is that you often will see situations where retaliation is hard to determine the exact identity. It may be whistleblowing, it may be race, it may be gender identity, it may be a number of things. And so it is very important, I think, to try to lay out a complete collection of options with respect to the various issues that might be at play in a particular person's situation.
All right, good. Now, Laurie, you, if you wouldn't mind winding up this section, and so we can move it.
Okay. I think just to wind up, I would just note that if the disclosure is part of a person's normal job duties, so for example, the person is an investigator and they're reporting something that they learned, over the course of an investigation, there can be sort of a higher burden for gaining protection. So you just kind of want to keep that in mind. And then just lastly, the process of actually filing the whistleblower retaliation complaint in the OSC is very easy. In the OSC, on the website, they have a form. You fill it out, you provide additional documentation, and it kind of goes from there. So, that should be relatively straightforward to do.
Thank you. Richard.
All right. Thanks, Laura and Julie. So I'm going to talk about a couple of different topics and have a fairly brief conversation about each one. And hopefully, if you all have questions, we'll hear them at the end and can weigh in on them. But I think one of the important considerations for many of the folks who may be listening to this call are that if you are an attorney, you obviously have some special considerations that you must take into account when you're considering becoming a whistleblower. And this is true whether you're a government attorney or a private sector attorney. And I've represented, attorney whistleblowers in both contexts. So I want to remind you of a couple of important things to keep in mind as you're considering coming forward with information and blowing the whistle. And most of those center around our ethics responsibilities as attorneys. And what I'm going to refer to now are some of the ethics rules that are in the DC Bar. The DC Bar is primarily modeled after the ABA model rules, and so your jurisdiction or the ABA model rules are going to probably be pretty similar, even if the numbering of the rule is a little bit off. But here are a few items that you need to keep in mind. First of all, under Rule 1.6, we all know that the client confidences and secrets must be maintained. And when we as attorneys are receiving information that might be considered a client confidence or secret, revealing that information is a violation or can be a violation of that standard, and so we have to be very thoughtful about it. So one important thing to consider when you're a government attorney is who exactly is the client that you're representing if you are acting in a representational capacity. Is it the United States? Is it your particular agency? Is it a particular government officer, such as if you're the general counsel to a federal agency? Those are matters that you should, be very aware of and identify, before you, take any steps to go forward. Now, there are exceptions, of course, to our obligations as attorneys not to reveal client confidences and secrets, and those include if we're taking steps to come forward to prevent a criminal act or to prevent bribery or intimidation of witnesses or jurors or others involved in proceedings that we're involved in or that our agencies or clients are involved in, or if our services as a lawyer are used to further a crime or fraud, and if bar rules or an order of the court allow us to step forward with a client confidence or secret, then that's permitted as well. And then finally, for government lawyers, client confidences and secrets in particular, at least under DC Bar Rule 1.6, can be revealed when permitted or authorized by law. So in those situations, which may include the rights that you have under the Whistleblower Protection Act, for those situations where there's a specific right under law to make the disclosure, you may be entitled to violate a client confidence or secret. A couple of other ethics standards to keep in mind, Rule 1.13 concerning representing an organization as a client, which many of you would deal with if you're working in the government. Rule 4.1 concerning truthfulness in statements to others, and Rule 8.3 concerning reporting professional misconduct. all of these rules interact with each other and also often relate back to rule and the requirements of Rule 1.6 regarding client confidences and secrets. So I would advise you to review those standards, to be thoughtful about what information you are about to share before you share it, and to even take the step of either consulting with bar counsel or with your own private attorney to make sure that before you take a step forward, you are not going to put yourself in any kind of jeopardy by revealing information that may be protected. And what is an important consideration here is that although the Whistleblower Protection Act is very broad in terms of what it may protect, the ethics standards that we as attorneys have to follow could hamper our abilities to fully utilize those protections under the law. And so just be very thoughtful about this as you move forward. I've talked with folks at the Office of Special Counsel about specifically how they treat attorney whistleblowers in their system that that Laura has described. And the current administration at the Office of Special Counsel is treating attorney disclosures as an intra-government disclosure, meaning that the OSC does not see a disclosure to it as violating an ethical standard because it believes that making a disclosure to the OSC is part of internal government communication. Now, as you might imagine, many agencies that have been subject to OSC investigations do not agree with that interpretation. And so although the OSC is happy to take your information, even if it might raise some ethical issues, your particular agency may take a very hard stand on that point. And so again, it's just a good idea to be careful about how you proceed. I will raise sort of one case example of this type of issue, and that is the case of Thomas Tam, who was an attorney in the Department of Justice, Office of Intelligence Policy and Review. And Mr. Tam is well known for having essentially revealed the information that indicated that we citizens, that our cell phone and other data were being unlawfully monitored by the NSA and possibly other government agencies. Mr. Tam apparently made his disclosure to a reporter, and that disclosure down the road was considered by the DC Bar to be a violation of Rule 1.6, the confidences and secrets restriction. And he eventually was publicly censured. That, as I understand it, was not obviously a serious type of action. It wasn't a suspension or debarment. And I think it was because the mitigating factors in his case were the importance of his disclosure and the fact that it triggered reforms within the government and made us all aware of a situation we were unaware of. But nonetheless, the Bar did take it seriously and found in his instance that he was still merited public censure. So it's an example to keep in mind about disclosing information in the context of serving as a government attorney. I'd like to turn now to the Special Counsel, the Office of Special Counsel, and what the tenure of that current Special Counsel is and why that's important. Carolyn Lerner is the current Special Counsel, and her colleagues have been operating during much of the Obama administration, the Office of Special Counsel. During that time, they have reformed that office in a number of very important ways, and as a result, they have received probably more disclosures and complaints of retaliation in recent years than many prior offices of special counsel have. They're a very good group. They're very conscientious, but they are very overworked. So that's another thing to keep in mind in terms of timing and timeframes, that when you submit something to the Office of Special Counsel, you're often not going to get as timely a response as you would like. But in terms of Ms. Lerner's tenure, my understanding is that she has tenure through June of this year, and that she has been renominated prior to the new administration coming in. But because she is an Obama nomination, it is probably unlikely that she will be reappointed as a special counsel. And so those of you concerned and interested in whistleblowing need to follow how that special counsel job gets changed and who gets that job in the future. So that's just something to keep in mind as we go forward here. Laura mentioned, aside from the Office of Special Counsel, a step
Richard,
out of that. Yes.
Could I interrupt for 1 second, because I wanted Laura, I think I cut her off. I wanted her actually, because we're running a little short on time, so I want to sort of shortcut what you have remaining and also have Laura actually establish the framework for this, which is, let's assume that you either represent or are an employee in the federal government who has a whistleblower claim. And you guys can work out on the run the facts that might be relevant. What would be the practical procedure, Laura, and what might be the downfalls in either procedure? Could we talk about that for a few minutes, and then we'll get into what questions we might have?
Sure, and I'll start, and Richard, if you want to jump in, please feel free. So it would depend on what action was taken against the employee. So if the person was fired and they wanted to, they could go directly to the Merit Systems Protection Board, and that's that entity that I mentioned before. That it functions, sort of like a court, and you have discovery and you have all of that, and you set out your case. And what you're trying to prove is that you made a protected disclosure. You need to prove that by preponderance of the evidence, and then if that's the case, then the agency and that the agency, took an action against you based on that disclosure, and then the agency would have to prove that it had another reason for firing you, essentially. And that's the sort of burden shifting scheme that happens there, and the agency would have to prove that had another reason for taking the action by clear and convincing evidence. So that's the sort of the basics of the Merit System Protection Board. If the action is more minor, which a lot of them tend to be, so maybe just a suspension or even just a significant change in duties or something like that, you can bring a whistleblower retaliation complaint before the Office of Special Counsel. And so you would just fill out the online form, and the Office of Special Counsel would start to sort of investigate that. And if it did, it's often successfully resolved through negotiations. But if it's not, then the OSC could initiate an enforcement proceeding and seek the corrective action on your behalf at the MSPB, although it almost never does. Richard, anything to add to that?
No, I don't think so, other than to say, and I think you touched on this a little bit, Laura, during your first discussion of these points, but I think it's important for folks to remember that not everything is considered protected whistleblowing. And so when we look at the statute, the protections that one has under the Whistleblower Protection Act are for issues that a person raises that they reasonably believe, and that's an important element, that your belief is reasonable. Something that involves a violation of law, rule, or regulation, gross mismanagement, or gross waste of funds, and these are pretty precisely defined and discussed in the case law on these issues. An abuse of authority, or a substantial and specific danger to public health or safety, and that's also something that's pretty closely defined in the case law discussing protected activity. And it's important to know, aside from the ethics issues I've raised, that protections do not cover disclosures of, say, national security or secrecy or information covered by secrecy provisions of executive order. The OSC does have a means of working with people who have classified or other secret information that is part of their disclosure but that needs to be discussed with the OSC specifically to ensure that that your disclosure is going to be a protected one and will not violate national security laws. So that's Laura. That's the only other thing I would add in sort of pulling this all together.
Mm-hmm.
All right, thank you both. I had one final question. The complexity of this area, the complexity in first in the actual underlying statute, making sure the relator has a valid claim, plus the process itself seems to me to argue for counsel. Yet it's a very difficult area, both because a lot of government people do not make that much money, and it calls for somewhat sophisticated counsel. What can either of you advise as far as concrete next steps, who to contact, further questions, offline, etc.?
Well, I'll start with that, and then Laura, you can chime in. I think, Julie, the point is well taken. If you're not a government attorney or employee that is familiar with the ins and outs of the Whistleblower Protection Act or employment law for federal employees, then you will need counsel to really help you navigate these issues. Although, as Laura has mentioned, if your issue is less serious in that you're not facing a proposed removal or a serious demotion or suspension of more than 14 days or something of that nature, then it may be that just working with the Office of Special Counsel, you can work things out. But I agree that what you want to look for is a firm or practitioner that has experience with federal public employee law. Certainly, our firm does that work. There are a number of firms in the D.C. area that do that work, and Laura's organization, PEER, does that work mostly with environmental employees or employees dealing with environmental issues. Look for a practitioner with experience because these are difficult issues and are sometimes fairly complex. And you'd be
Are they contingency cases? Are there damages or attorney's fees that come out of them? How do practitioners take the cases?
Practitioners will, it varies depending on, the business.
Oh, of course
model.
it does. Right.
But
Of course.
And some do require, payment of fees just straight up in terms of an hourly rate or some kind of flat fee arrangement. There are contingency possibilities, and there are attorney's fees that are awarded in certain types of situations. For example, if there's a termination and one is contesting a termination and is successful through the OSC or MSPB process, there would be compensable attorney's fees that would be paid. There's also, with the amendment of the Whistleblower Protection Act in 2012, there was also the addition of compensatory damages, which may cover pain, suffering, humiliation, and other things that haven't been previously available to federal employee whistleblowers.
Laura, you have the last word on this, and then we'll turn to any questions.
Yeah, I would just say, if it's an environmental issue, certainly give us a call if you'd like. But also the National Employment Lawyers Association is a great resource if you're looking for, an attorney, because they've got a state-by-state directory, and you can then search for, an attorney who specializes in federal employment or whatever it is that you're looking for. So it's NELA.org.
All right. Paul, now it's back to you.
Thank you, Julie. We did just get a couple of questions in, so I will ask those. I know that we are short on time. But the one question that came in is that if the Office of Special Counsel investigates a whistleblower action and is concluded without any repercussions to any supervisor, is the matter concluded forever, or is there ever a possibility for appeal, to refile, or to have the matter reopened?
And I'll just throw that out to you two to sort out.
Yeah, I'm thinking on it. I think it depends on what kind of case it was. I don't know, Laura, what you think. if we're talking about a case where there was a major adverse action, such as a termination or something of that nature, the possibility for reconsideration may be present depending on what the decision was by the Office of Special Counsel. I don't know, Laura, what do you think?
Well, if the Office of Special Counsel, there are a couple of different possibilities, I think. If what the gist of the question is the Office of Special Counsel kind of agrees with you but is not going to take the step of actually seeking discipline, what can you do? I mean, if that's the question, because the other situation is that the Office of Special Counsel just completely doesn't find in your favor at all, and it neither grants you any sort of relief in terms of the employment action, nor does it do any sort of discipline. And in that case, you could take an individual right of action to the MSPB, right? Presuming that the basis of the claim was whistleblowing.
What if you had sort of sent your request over the transom and then followed up with a lawyer or someone who actually, after an initial no reaction or whatever, and then followed up with the lawyer on the same request, sort of more personally? Would that be possible?
Can you say that again?
Yeah, the Office of Special Counsel will recognize, folks obtaining representation, and I've certainly been in situations where people started pro se and then retained me or retained others and come into the process. In terms of the current administration at OSC, that's not an issue. They will gladly accept your counsel, your choice of counsel to help work with them on your issue.
Okay, thanks. Paul, anything else?
Yeah, we got one more email, and this listener has asked, do you expect to see an increase in whistleblower actions as a result of the change in administration?
Wow, okay. Yeah, right. It depends. I mean, trans and LGBT civil rights law is going away, so people's natural inclination is to kind of burrow at times. I hope that's not the case, but I can't blame people for doing that. So I don't know in my area. But anyway, what do you guys think?
I think that it's certainly likely, and it's not uncommon, for example, with changes of administration, to have career employees confronted with new paradigms presented by a new administration that they feel very uncomfortable with or feel like maybe actually violating, current regulations or laws. And so I would expect, Paul, probably some uptick in whistleblowing activity, and maybe even a significant uptick depending on the way the Trump administration decides to handle some, sensitive issues like in the environmental or other areas.
Laura, what do you think?
Well, certainly in our realm, which is mainly environmental law, we do expect to see an uptick, and in fact, we've already had people calling us very concerned about what they're hearing coming out of this administration.
Yeah, I think we can generally anticipate. Certainly in my area, in federal court, mostly we can anticipate an uptick of litigation. Paul, I think that's it. Thank you again, everyone, for listening, and hopefully we've given you some helpful information.
Yes, thank you, Julie, Richard, Laura, so much for taking the time to be speakers for this very important panel today. For any of our listeners, if you have any additional follow-up questions directed to our speakers, please feel free to email me, and I will forward them along and try to help you make that connection. I just want to close by saying that the National LGBT Bar Association cannot continue putting together a quality program like this without your continued support. If you'd like to see more cutting-edge legal analysis, please consider becoming a member of the bar or renewing your existing membership. To learn more, please visit our website at lgbtbar.org. Thank you to our listeners, and once again, thank you so much to our speakers today.